Hi students, so we'll move on to our next topic, identifying weaknesses. So in this we can see like who is a weakness, what is the importance of a weakness, and what are the types of weaknesses, and the procedure for examination of a weakness in the court, and all those things. So we'll see who is a witness. So a witness is a person who gives sworn testimony in a court of law as regards facts or inferences that can be drawn therefrom. Or a witness is a person who gives evidence regarding the facts. A witness may be any person, like he or she can give some evidences related to the crime. Maybe he is the person who saw the crime uh, directly, or he may be the person entered to the crime scene first, like if a dead body is like a dead body is lying in some place, he may be the first person to inform the police, or anything related to that crime. If the person is capable of giving some evidences related to that crime, that person is called witness. And in Indian Evidence Act, from section 118 to 134, it deals with witnesses. So in section 118 of Indian Evidence Act, it says that all persons are competent to testify unless they are prevented from understanding the questions put to them or from giving rational answers to those questions due to tender years or extreme old age or disease. It means that anyone can give the testimony unless they are prevented from understanding questions. Such people like maybe children or old age people, maybe they are there because of their age. Maybe they can't hear the question properly, or they will not remember it properly because of their memory issues, or they can't see things properly. Such kind of persons, or some persons with mental disability, they can't give a true testimony. So these except these people, anyone can testify, anyone can be a witness. This is section 118 of Indian Evidence Act. And what is the importance of a witness? So witness assistance of a witnesses is necessary for the judge to conclude the case. So when the trial is going on regarding a particular case, this testimony from the witnesses is very much important, because they need evidences to conclude the case. So this witness testimony is also a part of evidence. So to conclude the case, for linking the case with all the evidences, they need the help of witnesses. Then it is the salutary duty of the witness who has the knowledge, the commission of the crime, to assist the state in giving evidences. If a person directly saw a crime, or if a person knows something about the crime, related some facts related to the crime, it's the duty of that person to inform this to the government, or inform this to the court, that I had seen this thing, or I know about these kind of things, this kind of like things happening around here, or conspiracy, I know about the conspiracy, like that. If he knows something related to that crime, it's his responsibility to testify before the court. Then the witness face challenges to their life and family, and are also exposed to risk, and therefore they should be protected under the law. When a person is ready to give testify, or ready to testify uh, in front of the court about the relevant facts about the crime, maybe uh, he will be threatened by the opposition party, or the persons who committed the crime, or the culprits. So it's very risk for him. So if he is exposed, it's very much risk, and they should be protected under the law. So the court should ensure their protection. Next, Black's Law Dictionary, they define as witness is one who sees, knows, or vouches for something, or one who gives testimony under oath or affirmation in person, or by oral or written deposition, or by affidavit. So the Black's Law Dictionary, they define it as Witness is one who sees or knows for something, or one who gives testimony under oath. While testifying in front of the court, the witness has to take oath that I will not tell any wrong thing. I will testify only the truth. Like that, he should take an oath. So that person is called as witness. Bentham told Bentham said that witnesses are the eyes and ears of justice. Even though some controversies are the eyewitness or the witness oral evidences are not reliable, but in some cases it helps a lot for finishing the case. Then there are two kind of witnesses, like one is common witness and expert witness. There are two kinds of witness: common witness or expert witness. So first one is common or ordinary witness. Common or ordinary witness testifies only to the facts observed by him. Like if I saw a crime, I can tell only that I saw that this person had murdered this girl, like that, or boy. I can tell like that only. What I observed only I can tell. I can't tell about the weapon used, or the wound on his body or the victim's body, or why the blood spattered like that, and why the body is lying like this. I can't tell like that. What I observed I can tell. The body, I saw the body on the water, and it was lying in this position. That only I can tell. More than that I can't tell anything. Like the common witness can't tell anything. His evidences requires only common intelligence and knowledge. This requires only common intelligence and knowledge, and he is not capable of forming any opinion or drawing conclusion from the facts observed by him. If I saw a body lying in the water or in the roadside, I can't tell why it is like that. As I said earlier, I can't tell why the body was lying like that, or why the blood pooled around his head or pooled around his body. I can't tell what is the why it is happening like that. I can't draw any conclusions from that, from seeing that dead body. So I can, for the observer or the common witness, he can say only about the facts observed by him. This is about common or ordinary witness. Next is expert witness. So one who is skilled in scientific or technical or professional matters. That is expert witness. The person should be this expert witness should be like he should be very skilled person in a particular subject or profession. So expert witness is a person who has been trained or is skilled or has knowledge or experience, or education in technical or scientific subject, and he is capable of drawing inferences or forming opinions on account of his professional training, or like he has the ability to draw the inferences from the or forming opinions from what he saw. For example, we can say that a doctor who conducts autopsy, or a fingerprint expert, or a handwriting expert, or firearm expert. So they are the expert witnesses. Section In Section 45 of Indian Evidence Act, the opinion of person specially skilled in the foreign law, science, art, identity of handwriting or fingerprint impressions are relevant. So expert witness is defined in the Section 45 of Indian Evidence Act. Expert evidence. Section 45 of Indian Evidence Act. Expert evidence is defined in the Section 45 of Indian Evidence Act. So expert evidence is a what? He is one who is skilled in scientific, technical or professional matters, and he may give his opinion upon facts which are either admitted or proved by himself or other witnesses at the trial, then based on his common knowledge and on hypothetical questions. Then whatever the opposition lawyer is asking questions to the expert witness, he should answer it very in a clear presentation, or in a he should present it clearly. What all things he has done or he knows about that thing, he should present it clearly, uh, and all the conclusion must be related to the facts only. So the ability in expressing an opinion is very much helpful for the success of this expert. If there is if there is a difference between medical evidence of two doctors, one who examined the injured person, like the other, and the one who examined the injury and one who conducted the autopsy, like that, there will be if there will be a time difference between them, and if the if the conclusions are different, like the opinions of this expert witness is different, which are not matching with each other, then what will happen, the accused get the benefit of the doubt. So the thing is that expert witness should carefully examine all the evidences given to him, and he should give a correct opinion only. And this expert witness can be both a common witness and an expert witness. When for example, if we take a doctor, when he describes the wounds on the body, he is like a common witness. And when he says that this wound is ante-mortem and this wound is post-mortem, or the drowning happens, and ante-mortem drowning or post-mortem drowning, like that, if he is explaining in such a scientific way, he will become an expert witness. Otherwise, he is a common witness. So this is about expert witness. Expert witness is a person who is skilled in scientific, technical and professional matters, and section 45 of Indian Evidence Act describes the uh, expert witness, and the expert witness should be very much clear about his opinions. If there is a difference in the opinions of two expert witness who examine the injury or autopsy, if there is any difference between their opinions, the accused will gets the benefit of doubt, and the case will not move further. So that he should be very careful. And there are various other classes of witness who assist to conclude the trial for the deliverance of justice. They are child witnesses, interested witnesses, trap witnesses, independent witnesses, hostile witnesses, eyewitness, and material witnesses. So this one by one we will check in our next session, and also we will see what are the procedures for examination of a witness in the court in the next session. Till then, if you have any till here, if you have any doubts, you can ask. So see you in the next session. Thank you.